So the videos so far have dealt with issues that are between the spouses themselves. So patrimonial consequences of a divorce on the one hand and spousal maintenance on the other hand. Those sort of things are usually fairly simple, provided you've got all the right information and you know each other's assets and liabilities and you know each other's income and expenditure. They're fairly simple. When we add minor and or dependent children into the mix, things can become a lot more complicated and there can be a lot more disagreements relating to the various issues that surround children, including their living arrangements, which we refer to as care and contact, and of course their maintenance needs. Now, my very, very first piece of advice to you, if you are separating from your spouse and there are children involved, whether those children are adult dependents or minors, is please, please, please do everything within your power to go to mediation and try and resolve the issues between you and your spouse through mediation before you approach a court. These kind of matters can become very complicated very quickly and result in enormous legal fees and enormous stress to both you and your children very quickly if they're not managed well. Mediation is always the best route to go, and I will endeavor to do some videos on mediation at a later stage so that you can get an indication of what that is about. But please do your research and, if at all possible, get yourself and your spouse into mediation so that you can resolve issues relating to your children before they become a disaster. So the Children's Act is a very detailed and very big act. There are so many sections in that act I can't even begin to tell you, and it's been amended a number of times. But there are very specific clauses that relate to care and contact that you need to comply with, and as spouses and as parents. And most importantly is that your children, in terms of the Constitution, have rights specific to them. And some of their very specific rights are rights to maintenance and rights to relationships and to have their maintenance needs met by their parents first and foremost, and then by other parties where that becomes necessary. You as parents, in terms of the Children's Act, because you are married, are automatically co-holders of parental responsibilities and rights. And let me just point out a few things here. The Act is clear that you are co-holders of parental responsibilities. That comes first. Responsibilities and rights. Responsibilities come before rights. You have legal responsibilities towards your children, and those are of paramount importance. Your rights are secondary to your responsibilities. That's why the Act is in that manner, responsibilities and rights. Now, another thing I want to tell you, just because you are co-holders of parental responsibilities and rights does not mean that you have 50-50 primary residence. The Act does not define primary residence. It's a term that is generally used and has always been generally used, and it continues to be generally used, and it refers to where the children live primarily. The Act does not mean that you automatically have 50-50 primary residence. Doesn't mean that. So please Don't start from with the idea that that is what it means. It doesn't mean that. At the same time, please also don't think that there is still this belief that there is a preference for mothers to have primary residence of children. It all depends on the circumstances of the family. There are many situations, and I've had many clients who are the fathers, and the father has primary residence of the children, or the parents do have a 50-50 arrangement. But every single case is judged, if you will, on its merits and on the circumstances relating to that family, those children, and those parents. And the sort of circumstances that are taken into account are things like which parent has been the more actively involved parent. You may have a father who's been the one who's taken the children to school every morning, made their breakfast, made their lunch, packed their sporting equipment, fetched them from school after they finished their extramural activities, taken them home, made sure they did their homework, and then mom is the one who's gone out and had the high power job in a corporate. It happens. And so the circumstances surrounding each and every family will determine where the children primarily reside or what their care and contact arrangements will be. And every single case is different. What works for you will not work for another family. What works for another family will not work for you or for your children. So please bear that in mind, because very often people come to me and they go, yeah, but my friend told me that her and her husband have 2-2-3 arrangements, which means they say two nights with one parent, 2 nights with one parent, 3 nights with the other, and so it goes. That may work for them. Doesn't mean it's going to work for you or for your children. Every single child has different needs, right? So please bear that in mind. And this is why I say to you, it is always better to try and get yourself to mediation, you and your spouse, so that you can try and resolve these issues without having to ask a judge, a single person, to make a determination as to where your children are going to live and who's going to exercise contact when. If the two of you as parents can come to an amicable agreement, it may take you a few hours, it may take you a few months. Give it your best shot to get to those kind of arrangements yourselves without the intervention of court. What happens if you don't agree and there is going to be a dispute? There's a few things that can happen. In a Rule 43 application where you've applied for maintenance for yourself, you can also use that to get an order relating to care and contact and also maintenance for children. Now, the maintenance for the children is determined by where they live and how often they see each parent. Because if they live in 50-50 and both the parents are earning the same amounts, then maintenance is going to be shared equally. Because maintenance for children is calculated based on the children's needs and then the parents' means. So let's not deal with that right now. Let's just deal with the care and contact. Now let's say you're in dispute and you want to bring a Rule 43 so that you can have primary residence of the children pending the finalization of the divorce with your spouse to exercise contact every alternate weekend, for example. Very often, what the court will ask for prior to it giving an order is it will ask that the matter be referred to the Office of the Family Advocate. Now, the Office of the Family Advocate has specifically been set up to resolve issues relating to care and contact of children. They don't deal with maintenance. It's only care and contact of children, right? So if the court asks for that and the court wants you to go for that, a Rule 43 application could be adjourned to allow for that process to take place. Now, the Office of the Family Advocate has a limited resources, has limited capacity, and has so many matters being referred to it, because there's now also the Children's Court and family courts that also refer matters to it. Domestic violence courts can refer matters to the Office of the Family Advocate. So the Office of the Family Advocate generally takes quite a substantial amount of time to, number one, consult with the parties, and number two, finalize a report. So don't expect that to happen in a hurry. This is another reason why I say, if you can get the matter to mediation, it is way better for you, for your spouse, and especially for your children. The other important aspect to remember when it comes to care and contact of your children is that, in terms of the Children's Act and the Constitution, is that children have a right to have their views considered. Now, the terminology that's used is problematic. Some people like it, others disagree with it. The commonly used term is that the voice of the child, and I actually did my master's degree on the voice of the child, but in fact it's technically incorrect. What the legislation says is that children have a right to participate depending on their age and their stage of maturity. And what that means is that if you are going to make a decision about where the children are going to live, and your children are 16 and 12, and they are, quite smart kids, and they're doing well at school, and they've got a good understanding, they have a right to hear what the decision is about what's going to happen with them, and to have an input into that. They're entitled to participate. Now, the Office of the Family Advocate, when they call you and your spouse into, first they try and mediate between you, but if they're going to investigate and do a complete inquiry, then they will speak to both of you, and they will speak to your children, regardless of your children's ages, unless they're really small, like, below the age of 3. But if they're little, they will watch how the children interact with you, to see how they interact with both parents, to see that there's no, the child doesn't go running off screaming when they see one of their parents absolutely terrified or anything like that. And when the children are older, they've got things that they do with the children through drawing and play, where they can get an idea of what the children's views are and give them an opportunity to participate in that process, because children are entitled to that. More experienced mediators could themselves bring the children in and meet with the children to get an indication of what the children's views are, could explain to the children that, what you as parents have think is in the best interests of the children, and then get the children to give their views on what the parents have discussed. It all depends on the mediator you get if you decide to mediate. The court is unlikely to make a decision about that without the input of an expert. So if it's not the family advocate, then, and you and your spouse are still in dispute about where the children are to live, or how much contact they are to have with the other parents, or if you want to stop the other parent from having contact because the parent is an alcoholic or a drug addict or whatever the case may be, you're going to need to get an expert opinion. And this could be a psychologist or a social worker who specializes in that type of forensic work. But please bear in mind that all these types of interventions can become incredibly expensive. And especially forensic investigations into care and contact, because they do psychometric testing of you and your spouse, and they meet with the children, and they meet with collateral people, teachers and family and friends and all that type of thing. So these type of investigations can become incredibly expensive and can also be traumatic to you as a family and to your children. So you want to try and limit those things. So the outcome that you want to try and achieve is always based on what's in the best interest of all children. So if you've got special needs children, for example, a 50-50 type arrangement might be too disruptive for them. Or you've got a child who does a lot of sport and, one of you as a spouse does a lot of traveling and can't be there on a regular basis to take that child to sport, to make sure the child's got everything he or she needs to get to and from school, and therefore the child needs to stay with the other parent. These are the type of things you need to take into consideration when you're deciding on the care and contact arrangements that are in the best interests of your child. Of course, you also need to take into consideration whether or not there are any issues such as drug or alcohol abuse issues, right? These are very important, obviously, because they will affect how a parent is able to cope with parenting, and in particular with single parenting. So these are the things that you need to think about when it comes to care and contact. Maintenance for children is calculated much the same way that maintenance for a spouse is calculated, except that it is then, once the needs of the children are determined, a pro rata type calculation is done based on how much the parties are each earning to determine how much the one spouse must pay to the other spouse for the maintenance needs of the children. To avoid further arguments arising, it is always best to try and have the spouse that is not the primary caregiver pay the maintenance directly to service providers. So, for example, paying school fees, school uniforms, stationery, paying medical aid, paying for medical expenditure, etc., and reduce the amount of cash maintenance payable, because unfortunately this can be abused, or allegations of abusing this can be made, where the parent who's paying says that the parent who's receiving the money is spending it on having their hair and makeup done, or buying the latest shoes and matching handbag, rather than spending it on the children themselves. Now, when you calculate the needs of a child, all the shared household expenses are taken into account. So, for example, rent or a bond installment is shared between the parents and the children. There are different schools of thought on this, but the generally considered most commonly used one is that it's 1 part per child living in the house and 2 parts per adult living in the house. So if there are 2 children and 1 adult, it is essentially divided in half. 1 part for each child, 2 parts for the adult, so 50-50. So if your rent is 10,000, 5,000 of that is allocated to the children and 5,000 to the parent. And that is with all the joint household expenses. So that would be groceries, electricity, rates and levies. If there's a motor vehicle that is under finance, it's the motor vehicle, it's the petrol, it's the licensing fees, it's the dog food, the cat food, the vet's bills, the medical expenses where they are shared expenses. So, for example, if you keep over-the-counter medications, those sort of things are included in that. So calculating expenses for children is different to calculating expenses just for a spouse if they're on their own. Direct expenses obviously then are directly for the children. So for example, if each child has their own cell phone or laptop or whatever, that will fall under just the children's expenses. If the children are at a specific school or university, those expenses are allocated to the children themselves. So some expenses will be joint type of expenses, and those are shared on that pro rata basis, as I explained. Or there are certain expenses like educational and medical aid and those sort of things that are expressly for a child and are put under a child's expenses directly. So when calculating the expenses for a child, it's a different calculation that comes into play. Now, let me see. Have I covered everything that you may need to know with regards to care and contact? There are a lot of nuances in care and contact that are very difficult to explain over an email, over a video, and are very sort of case by case. One of the things that quite regularly comes up is the question of, do I need the consent of the other parent to travel locally with the children? The answer to that is no, you don't. Do I need the consent of the other parent to relocate from one province to another? Yes. You don't necessarily need their consent, but you do need to take into consideration their views. So in other words, you have to tell them and before you move, and you have to let them express a view about that. And whether or not you can relocate will be based on the care and contact that is currently in place, and how you're moving will affect that. Then what comes up quite a lot these days is relocation to another country. And this is a whole different thing that can become extremely complicated, and I'd definitely have to do a whole series of videos on that. But that is something that you definitely 100% need the consent of the other parent, and it would have to be written consent, and you would then need a court order to give effect to that. So those are things that come up quite regularly. Then the other thing you just need to bear in mind is that parenting plan for care and contact of children is never fixed in stone. It is a flexible document, and it has to be, because children's needs change as they grow older, as they mature, as their schooling changes, as their sporting changes, their extracurricular activities change. All of those things have to remain flexible. So it's not something that is set in stone. Parents will often say, oh, but I need it to be that it must say that the parent will collect at 5 o'clock on the dot, and if they're late, then that's going to happen. It can't be like that, simply because life happens and things happen. And if, for example, unexpectedly you get called out on an urgent business meeting or something, and you can't collect the children at exactly 5 o'clock, you've got to be able to allow to be flexible, that you might be a little bit late, or on another day you might be a little bit early. So these are things that you need to bear in mind when it comes to care and contact of children, is that parenting plans are not fixed in stone. They are always flexible. And as parents, you need to be able to co-parent your children and be reasonable with one another at all times. I hope this helps, and please, again, if there are children involved in the mix, please, 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 whatever you do, try and get your spouse and you to mediation as soon as you possibly can, preferably before you've even instituted divorce proceedings, if that is at all possible.